Hello, everybody, and welcome back to another Conserving Catholicism episode. My name is Nick,
I'm Adam.
and today we have a very special one. The date today is June 30th, 2022, and we are a week after, 6 days,
Just about a week.
just about a week after the Dobbs v. Jackson decision has come out from the Supreme Court, the Dobbs v. Jackson decision, which has overruled the previous two awful court cases, Roe v. Wade and Casey v. Planned Parenthood, as stated by the justices and by Alito in the Dobbs decision. The court held that, quote, the Constitution does not confer a right to abortion. Roe and Casey are overruled, and the authority to regulate abortion is returned to the people and their elected representatives. I don't know about you, Adam, but just hearing it, it gave me chills, honestly.
I was sitting in my little cubicle at work, and when a friend texted, he said, "Did you hear?" So I immediately, went and pulled up the PDF, and like my eyes, searching for this on the syllabus for the court holds, section on every published opinion, and I remember reading that, and it was just like, I think it's sunk in a little bit now because we've been talking about this, you and I, and of course I'm sure in our respective circles have been talking about this for the last 6 days. So it's sunk in a little bit, but initially it did not, but it was still of course a very joyous day for it to happen on the solemnity of Nativity of St. John and the Sacred Heart was I have an old priest of mine growing up. He said there's no such thing as a coincidence, and I think that an event like that kind of proves that.
Yeah. I remember that day I was sitting in the office doing work, and I was expecting the decision because the day before the court had announced it, so it was on a Friday on the 24th, and I'm not going to forget that date. June 24th is going to definitely be, I think for all of us, it's definitely going to be a date to remember. But I remember, so it was a Friday, and the Thursday before, the court usually releases their decisions. I believe it's on Mondays and Wednesdays. And so I think it was on Wednesday or the Thursday, they announced that they were going to do an additional day in the week that they were going to announce decisions. And so it was kind of people were presuming, okay, this might be the date that they do it. And so I remember I was refreshing on my phone, and then sure enough, I just went back to work. I refreshed at 10 a.m. because that's when they start releasing decisions. Nothing happened, and then I get the message in our staff group chat saying that Roe v. Wade is overturned, and none of us heard it. We're like, where are you seeing this? I tried looking it up. Nobody had reported it right then and there yet.
Yeah, it took a couple of minutes for it to join the news.
Yeah, and then sure enough, it did, and we all celebrated. We ended up going straight to the chapel to pray because we were all just super excited. That day, I almost couldn't get any work done because I was just so focused on. Yep. And so it's definitely it was a great day, a great day for life. Obviously, as we'll discuss later, the fight for life isn't over, but it's certainly, this was, I think, certainly a big victory, and probably the biggest cultural victory certainly in our lifetime, but maybe in the past 50 or 60 years in the United States.
Absolutely. Yeah. And I was talking with a couple of friends the other day, and it's, when people, I'll use the term conservative kind of loosely, but when conservatives finally get a win, we have no idea what to do because we're just like, our whole thing is just complaining about how we're losing everything, whether it's the cultural war or whatever have you. But it was kind of, you feel like that episode of The Office when Kevin, I forget the context, when Kevin's like, it's just nice to win one, like that, of course. And I'm understating it completely, but it was an incredibly joyous day. But you're absolutely right to point out, and again, as we'll discuss later, it's one step. It's a big step, one that we should celebrate, but it is just one step in a long march towards, respecting the sanctity of life, not only in just the United States, but also in all nations across the world. So, but certainly something to be very, very happy about.
Absolutely, yeah. And so, I mean, with that, we might as well get into what we're trying to talk about today. Obviously, it's a great decision, but we also want to get into just a little bit of the nuts and bolts for you guys to understand what the decision is, what the decision is not, what it is saying, what it is not saying, because obviously there's a lot of confusion out there on social media. You'll see a lot of people tweeting things or messaging things saying that, oh, this is what the court is doing now. And it's like, no, that's not actually what it's doing. So we're hoping it clears some of that up for you guys. Obviously, we're not legal scholars, so we're not going to be able to go into all the nuts and bolts about the decision, but just the general gist and takeaways that you guys may want to know going into your conversations with people, or just to give you better understanding generally, because knowledge is good. So,
yeah. And I think it's also good for us, John. It was certainly good for me to kind of not only read the Dobbs decision in full and try to understand it, but also prompted us to go back and read Roe and read Casey and just kind of refresh on the general trajectory of the abortion debate in and outside of the court in the last 50 years or so. So I'm sure if we're wrong about something, hopefully people will correct us in the comments or wherever this is posted. So
yeah, please do, because I don't know about you, but I have only given it one full read through
same here.
The decision. I didn't read the dissent. Frankly, didn't find it to be that important to read the dissent for our present purposes. I'm sure at some point I'll try to give it a read, but yeah, so I've only given it one full read through, but I'm sure there's a lot more to glean from it upon a second or third glance. But this is just our kind of initial takeaways, and it's good to just articulate it, process it also for our own purposes. So with that, we'll give some background information before we go into the actual Dobbs case and what it's doing, as we mentioned in the introduction. So Dobbs v. Jackson has overturned the two landmark watershed decisions in our nation's history, Roe v. Wade and Casey v. Planned Parenthood. So we'll just quickly summarize what those cases are, so that way when we say that these were overturned, you understand what was overturned, and we'll go from there. So beginning with Roe v. Wade, this was the first major case that was decided on the issue of abortion in the Supreme Court in the United States. In 1973, this case was decided, and this case is the one that established a so-called right to abortion, and it did this in such a way. So the right to an abortion obviously doesn't appear in the text of the Constitution, so it's not an explicit right in there. So they called it what's called an unenumerated right, a right that's not specifically enumerated in the Constitution, and they said that this right was is grounded in another unenumerated right, in a right to privacy. So you just start seeing a Russian nesting dolls of unenumerated rights, and the unenumerated right to privacy was established in Griswold v. Connecticut, where they said there's an unenumerated right to privacy in here, and that right to privacy extends to matters of matters of the bedroom. So it includes like a right to use of contraception, and this right to privacy is grounded in like the First, Fourth, Fifth, Eighth, Ninth Amendments, I believe.
First, Fourth, Fifth, Ninth, 14th.
First, Fourth, Fifth, Ninth, and 14th Amendments, and in the penumbras of the Bill of Rights. So it's all over the place. But anyway, what Roe ended up with saying is that, okay, so the right to privacy, as Griswold says, extends to the right to acquire contraception, and it also then extends to the right to procure an abortion. And it set up what's known as the trimester framework. So the trimester framework that we use to speak about the unborn in the womb, where we say the first, second, third trimesters of development, that was established or set up by Roe. And so what Roe said was, okay, in the first trimester, no restrictions on abortion are allowed. So the mother and her provider can have a discussion about any kind of abortion procedure that the mother may want. After the first trimester, you can have some restrictions on abortion, but they can only be restrictions to for the maternal health. So you may restrict the kind of procedures that you do just to make sure that the mother doesn't die or undergo severe complications. And the only time at which you can procure or you can restrict abortion, that the state can restrict abortion, is after viability. So the main thing about Roe is this viability line. Before viability, no restrictions unless it's to protect the mother. After viability, the state can restrict abortion. So this is one of the quotes directly from Justice Blackmun, who penned the majority opinion decision. And Justice Blackmun writes, quote, with respect to the state's important and legitimate interest in potential life, the compelling point is at viability. This is so because the fetus then presumably has the capability of meaningful life outside the mother's womb, end quote. So if you're listening to that and you're like, something seems a little fishy about that, you're right. The fishy part is that it just says that the reason why the state interest begins at viability is because at that point the fetus is viable outside the womb. And it's one of the problems that we'll get into about the decision, which is why it was overturned. But that's just a general gist of Roe, what it set up, the trimester framework, the importance of viability, and the first establishment of the right to an abortion in the United States' legal history. So hopefully that is a great summary.
Yeah, no, thanks for that. And so I'll take on describing a little bit of the nuts and bolts of Casey. And I mean, there's a lot that can be said about it. I'm just going to mention a couple of points just to throw it in context to Roe, and also, of course, in context to the Dobbs decision that overturned both. So one, my first point is that Casey affirms Roe in that the Constitution does confer a right to seek an abortion prior to viability. Notable difference, or it's at least an interesting one, is that whereas Roe couches it in terms of the right to privacy, which it gets from the Griswold decision, Casey relies more on the idea of liberty. And you see this throughout the decision. There's that infamous part of the first first couple of lines, or it's in the first couple of pages at least of the decision, says that at the heart of liberty is the right to define one's own meaning of existence, et cetera, et cetera. So it's a very famous or infamous phrase that serves as sort of the cornerstone for the reasoning. And again, like you mentioned, viability, and again, Casey champions the viability line that Roe initially put in place. One of the main differences between Casey and Roe is that Casey replaced the trimester framework with what's known as an undue burden standard, which claim that law is invalid if its specific purpose can be argued to, if its purpose is to place substantial obstacles in front of a woman who is pursuing an abortion prior to viability. So it's even less, it introduced more of a gray area than Roe, where Roe had a specific kind of schema, that a trimester schema, even though it was completely just made up by the court itself. At least it was a little bit more specific and clear than the undue burden standard. But again, viability being that a really important through line between both decisions. And so I just like to highlight two specific things about both decisions. Again, there are manifold differences, and I was thinking earlier about kind of going more in depth about the differences, but fortunately, even though it's a matter of academic interest right now, it's really not even a matter of legal interest, apart from, you know, armchair conversations, because both were overturned, which we'll obviously discuss in just a minute. But two things that are very significant, because they're both similarities between the two decisions are they both hold that the Constitution guarantees a right for a woman to seek an abortion prior to viability, and that it also couches the right to abortion and restrictions on abortion in the language of interests between the mother and the state. Whenever you see like the child mentioned in either decision, it's usually referred to as a potential life. So it just shows kind of the reasoning is always between, you know, two competing interests. On the one hand, the mother, and on the other hand, the interest of the state, which of course the interest of the state is basically just another way of saying political action. And if you say that the state has no interest in this, or has no compelling interest, then it is unconstitutional to create a law that would exercise such an interest. But of course, now we can get into the good part, that both of those decisions are now overturned.
Yeah, and I will say, but before one more thing before we get into that, just as you mentioned the other day, because it might be just helpful to explain quickly that although the Roe and Casey both say that you can't restrict abortion before viability without some undue unless there's like an undue burden standard or whatever it might be, the framework. that although it doesn't allow you generally to restrict abortion before viability, it doesn't then say that abortion then is outlawed after viability.
Right. It just gives the option under specific circumstances. Again, in the case of Roe, that second trimester is where the state kind of the interests start to emerge, however slowly or gradually for the state. But yeah, I think it's an important point. It's not like abortion is then just cut off after viability. It's just that the state is recognized by these two decisions as having more of an interest. The ability is there, the potential is there. Yeah, no, it's a good point. It's a good point to raise.
Yeah, because I think it's important too, as we'll see with Dobbs, exactly like what it is that the court is saying that states can and can't do, and it's very different things, and it's I think part of sometimes the misconception with what the court is actually doing when it comes to, is it forcing the state to do something? Is it forcing the state not to do something? What's going on here? What is the state allowed to do? What are we allowed to do? And it builds up. And so it's important sometimes to just keep track of these things that may be seemingly small, but definitely have major consequences, especially in the long run. So with that, yeah, we'll get into the fact that now Dobbs v. Jackson has overturned Roe and Casey, and the big question is why. Obviously we can just chalk it up to saying that Roe and Casey were wrongly decided, and this is true. That'd be the kind of the cop-out answer. It's good to understand the court's reasoning in these decisions, and so that's why in cases like this, especially in cases like Dobbs v. Jackson, which overturn supposed precedents like Roe and Casey, it's really important to see how the court justifies overturning a decision. But even just the decisions themselves, it's important to understand how they justify it, because it can then clue you in into how the courts are going to respond to other things potentially, later on. And so it's a good for understanding that. So with that, we've heard some worries from some people that overturning Roe v. Wade and Casey v. Planned Parenthood, the fact that the court has done this is now going to overturn decisions like Obergefell v. Hodges, which founded a right to so-called gay marriage, or Griswold v. Connecticut as well, that we mentioned, which founded a right to contraception. And we see that there's some worry here. Okay, look, that means like these are next. Or some people think that those rights are now gone, essentially, because of this. What do you? I guess I'll just ask it this way. What do you think why do you think that those cases, if you do think that they're unaffected by this?
Well, the most clear answer, I think this is the most clear and effective answer, because it's consistently repeated by the court in the Dobbs decision. And it's also alluded to, although not in these terms, in Casey and I believe in Roe as well, as like the uniqueness of abortion, in that there's a categorical difference, because the result of an abortion is the determination of what we call its life, right? But whether it's potential life, in the language of Roe and Casey. So there's just categorically different types of cases, so that the overturning of two, in this case, Casey and Roe, the overturning of an abortion decision really has no bearing on overturning decisions made on other claims of substantive due process, such as Griswold and was Obergefell the substantive due process as well? Yeah. And right, because obviously it's unenumerated, so I guess it would have to be. So that would be like the easy answer, or maybe not so easy, but I don't know. That's the one that comes to mind for me. I don't know if you want to add to that.
Yeah, no, I think that's right. It's just, the unique nature of the case. And Alito stresses that several times throughout. They go through actually, they reiterate it so many times. I don't know how many exactly.
And also concurring opinions as well. I know Justice Thomas definitely stresses that. I believe Justice Kavanaugh does as well. Because in the flurry of articles that I shouldn't call it a flurry, it was a veritable avalanche of articles that you saw in the days after the decision. It was not only, of course, people mostly on the progressive side, lamenting Dobbs, but also saying, oh, now they're going to take away contraception, gay marriage. And it's like, this is just the first domino to fall. However good that would be, that's actually not the case in terms of Dobbs v. Jackson as a decision.
Yeah, and you see a lot of the articles that were circulating too was on Justice Thomas's concurrence, because Justice Thomas text is called substantive due process. I don't know if you want to. It's a large concept to tackle. I don't know if you want to briefly just talk about what substantive due process.
Yeah, as I understand it, it's we've used the term enumerated and unenumerated rights. So obviously an enumerated right in the Constitution, like the right to bear arms, for instance, it's written, in the Second Amendment. So anything that is specifically in the text, right? So this is why originalists, for instance, and I don't really count myself among them, but originalists love the text because everything is enumerated for them, or at least they claim everything is enumerated for them. Whereas an unenumerated right would be something that is implied by the text and also the broader history of the nation, this particular nation's legal and cultural history, right? It's firmly and objectively embedded in kind of the legal culture. So the United States, obviously, you could refer all the way back to common law through our legal traditions up until today, which is precisely what Justice Alito does, I think, quite successfully in showing how there is no such substantive right to abortion in the common law and in British law and in American history. In fact, it's quite the opposite case. And so he doesn't, to your point, and excuse me, to your point about Justice Thomas's opinion, although he's no fan of substantive due process, in fact, he wants it, a lot like Scalia did, he wants it gone. A lot of Alito's opinion is dedicated to saying how using substantive due process, the standards that the court has set for evaluating whether there is a substantive right embedded in the Constitution, to show that abortion is very much not the case. In fact, it's the opposite case.
Yeah, and so you see that Thomas obviously rules in favor with the court in overruling Roe v. Wade and KCV Planned Parenthood, but the reason why he has this separate concurring opinion is because he takes a larger issue with the idea of substantive grounding these substantive rights in general, and so he has a larger problem with substantive due process. It's a mouthful, and that kind of like jurisprudence of the 14th Amendment particularly, and so he writes his concurrence, and he doesn't suggest that the reason why there's no right to an abortion in the Constitution. What he's not saying is that there's no right to an abortion in the Constitution because there are like substantive due process is bunk, and there's no substantive right to an abortion implied anywhere in the Constitution. That's not the argument he's necessarily going down, if I'm understanding that correctly. If it were, then if he's challenging substantive due process specifically, then you would have an issue maybe with other court cases that have argued for or generated certain rights because of that, like Obergefell, like like Obergefell, like Griswold, like Lawrence. So you have that issue. And so Thomas definitely wants to open the door to a future case in which they can actually review their jurisprudential practice of substantive due process, but he recognized that this isn't the case for it, and therefore this case doesn't affect those other cases. And as you mentioned, in fact, this court actually uses substantive due process and says the right to an abortion doesn't meet the criteria to get it. And so it actually, if anything, it only kind of reaffirms that substantive due process as a legitimate way of reading the Constitution.
Yeah, absolutely. And again, I don't want to take us too far afield, but I definitely don't take the full-on repudiation of substantive due process. I don't subscribe to that, because I think you do. There's one's legal inheritance, like ours being primarily English common law, but also just our history up until this point, that you could make pretty compelling arguments about unenumerated privileges, immunities, and rights, that are not specifically in the text of the Constitution. But I think this decision is a masterclass in showing that you can't just pull it out of thin air, and conjure up a right to privacy out of that, cobbling together a bunch of amendments, or you can't, the right to abortion based on those same amendments, or also maybe, as Casey does, just kind of leans on the 14th Amendment's due process clause.
Yeah, I would say this decision is it's a very principled way probably of using substantive due process. And it shows, it's almost, you can almost use it as a case study for the correct way to apply substantive due process. Yeah. And in following that too, I think another point to get to our next point is stare decisis and precedent, something which
is another fun thing to say.
It's very fun. Much easier than substantive due process. Stare decisis.
It sounds smarter too because it's in Latin.
Yeah, exactly. And so make sure that you guys keep that in your back pocket for your fun legal parties that you go to on the weekends. But stare decisis, another thing that gets brought up, but I think that the court in this case gives another great example of how stare decisis is supposed to be applied. So backing up for a bit, do you want to just briefly state what stare decisis is, what the contention is from the dissent, let's say, about why Roe v. Wade and Casey v. Planned Parenthood should be affirmed and should stand?
Yeah, absolutely. So stare decisis, I believe the translation is going by what stands, or appealing to what stands, something like that. But basically, it's respect for precedent, right? It's a legal principle. It's not a law. I mean, what you'll see often in Alito's decision, and probably in many others, is that stare decisis is a principle, not an inexorable command. So it's certainly respected among jurists, but it's not an inexorable command, something that you have to do, or else, as we'll probably discuss a little bit later, if every precedent had to stand just by virtue of being a precedent, then there would be no such thing as an overturning of a decision. But there are some arguments that are made, mostly consequentialist arguments or stare decisis, that if you overturn a decision, it would damage the legitimacy of the court. It would have other unintended legal consequences. You'll find that I think it's called interest reliance is I believe here, I actually have it here. I don't want to get this wrong. Yeah, reliance interest, which is an argument attached to stare decisis, which would say that if you overturned a certain law, even if that you can decide that law is egregiously reasoned, removing it would have consequences that other people will rely on that. So it would just be like an untenable consequence as a result of overturning that law. So those are a lot of the familiar arguments, a lot of which I'm actually sympathetic to, about respecting what comes before. And it's basically just to respect that, one's institution, in this case, the Supreme Court, and the people that have inhabited the court before you, made decisions, and you ought to take what they had to think seriously. But again, it's not as though stare decisis is ironclad in always and everywhere. Again, if that were the case, then nothing would ever have the potential to be overturned. There are, as we've mentioned, and again, Alito's opinion is a masterclass in this, specific standards that one can apply when evaluating whether or not whether an opinion should stand on the basis of stare decisis, on the basis of it being precedent. And again, I think there's a definitive blow dealt to both Roe and Casey in Alito's decision, which says that no, it doesn't stand up to it's egregiously reasoned. It does not comport with the history and the traditions and the customs of our legal tradition, or any legal tradition in that is, of which we are an inheritor. It doesn't pass workability, and it doesn't pass the standard of interest reliance. So therefore, it doesn't, stare decisis ought not apply. In fact, should not apply given the reasons that he states.
Yeah, and this question too on stare decisis, unlike substantive due process, you find obviously throughout all the judges unanimous respect for stare decisis, and Alito as well treats it at a very high bar too, and he gives the two reasons for why stare decisis is a good guiding principle, is because the first reason he gives is that it makes sure that cases don't keep on being relitigated in the courts. So you don't just see people arguing the same kinds of cases in the courts over and over again, because if there was no stare decisis, if there's no principle for, you might get a different result each time. And so obviously you don't want people doing that. So it disincentivizes people from continuing to go back to the courts to argue the same issue. And also it's provides a certain measure of predictability, in the sense that you know that based on how the court has ruled in these cases, that they're going to rule in a similar fashion in future cases. And so you almost have an argument from an analogy, but you realize that, I think the way Alito describes it is that analogous cases are going to be ruled analogously, or similar cases are going to be ruled similarly. And so you have a measure of predictability in the courts. And so he treats stare decisis with a lot of respect and caring for stare decisis. The issue is okay, how do we apply stare decisis to this case? And honestly, I think that maybe I'm wrong on this, but to me it seems the argument that the justices might have found most compelling is probably arguments based on precedent. The fact that this precedent has been established. Not only that Roe has established it, but that Casey reaffirmed Roe's conclusion. And so that seemed to be the most compelling argument. Again, it falls very short, but the most compelling argument from the dissent is that we have this precedent, and there are serious consequences that can happen, as you've mentioned before, that if we repeal this, there are going to be drastic consequences, and or that the court may look too political, and that there might be some kind of breakdown of the court because of it. And so it's something that I think the majority of the opinion, they devote primarily to giving a stare decisis analysis to Roe, something which they said that Casey doesn't do. And as you mentioned, it's not an ironclad rule that you just follow blindly and you're bound to it. As Alito says, when certain cases are egregiously wrong and they're ruled egregiously wrong, and the logic is extremely flawed, he says stare decisis is not supposed to be a straitjacket. You're not bound and confined to it. And so what you need to do is in order to be able to check if the court's ruling is legitimate, if it was good, you need to kind of give this full sweep analysis, which they do. They give a great historical survey of the common law, in not only in the United States, but they even go back to England to look at the common law there and see how they've treated abortion, and how they've treated protecting the unborn, both pre-quickening and post-quickening. But they do this great historical survey, and as they say, that you need to give each case kind of its own stare decisis analysis. And with Casey, they say Casey just didn't do that for Roe. Casey didn't look at Roe on its merits.
It just took for granted that it was oh, hey, we like this. This is precedent.
Yeah, and so what the courts here are doing is they're saying we're doing what Casey didn't do, what they should have done when they ruled, or before they ruled, which was look at the merits of Roe itself, and they didn't do that.
Yeah, it's ironic also that Casey champions Roe a lot on the basis of stare decisis, but also changes so much of what Roe established. Obviously, the replacement of the trimester framework with the undue burden standard being like the most notable and most consequential of them. But there's also a lot of the little things that we don't need to get into here, and honestly, I wouldn't be able to comment on off the top of my head. That so it says, yeah, Roe, we should affirm it, among other things, because of stare decisis, but we're going to replace and change, if not completely contradict, some of the very reasoning of the case that we're claiming is just like this monumental precedent. There's another little just piece of irony here.
Yeah, and another problem too that you see is there's this discussion of, okay, what kind of precedents do we keep? And they give certain criteria of how to determine, okay, what precedents stay, what precedents go. But you see this very strange defense of stare decisis from the dissent, and And Alito says in the case, another thing too I love about this opinion is that Alito is very clear and in his writing. He doesn't. He's not very not nuanced. That's not the word I'm looking for. He's not very ambiguous in his writing and his statements. He makes things very clear cut, and I really enjoy that. But he says that it's not that we're ignoring stare decisis. It's actually that the dissent's view of stare decisis is broken from tradition. And he says that their conception of stare decisis is wrong. The problem with just constantly reaffirming precedent and just not necessarily a problem of reaffirming precedent in and of itself, but doing so in a blind fashion is that you might have now some laws and cases that we obviously think are wrongly decided. One of them being Plessy versus Ferguson.
I think that's like the classic example.
And Plessy versus Ferguson, for those of you that don't know, basically supported separate but equal, saying that was constitutional, and then it was overturned eventually by I don't know, I forget how many years later. Is it 40?
Well, it was 1954 was Brown v. Board.
Yeah, Brown v. Board of Ed.
So almost 60 years later, because Plessy v. Ferguson was 1897.
Yeah, it's sometimes toward the end of the 19th century. So yeah, about 50, 60 years later.
Yeah.
But yeah, so Brown v. Board of Ed overrules Plessy versus Ferguson, says that separate but equal is unconstitutional. But if you have this stringent view of stare decisis that no matter what, you kind of need to keep holding to this precedent, you have these egregiously wrong cases that just get to stay. And I think at one point too, they give a footnote of all the cases that have been overruled in the court's history, and the footnote's a page and a half long of cases that have been overruled by the Supreme Court. And one last thing is just that there was this one real good response to the dissent that I have here about the dissent's view, because the dissent had pointed out that stare decisis should when a case should be overruled. And so this is a quote, a little bit of a lengthy quote. I'll read it quickly so we won't go on too much longer on this. But Alito writes, quote, "The dissent argues that we have abandoned stare decisis, but we have done no such thing, and it is the dissent's understanding of stare decisis that breaks with tradition. The dissent's foundational contention is that the court should never, or perhaps almost never, overrule an egregiously wrong constitutional precedent unless the court can, quote, point to major legal or factual changes undermining the decision's original basis," end quote. To support this contention, the dissent claims that Brown v. Board of Ed and other landmark cases overruling prior precedents, quote, responded to changed law and to changed facts and attitudes that had taken hold throughout society, end quote. And then he says, "The unmistakable implication of this argument is that only the passage of time and new developments justified those decisions. Recognition that the cases they overruled were egregiously wrong on the day they were handed down was not enough. The court has never adopted this strange new version of stare decisis, and with good reason. Does the dissent really maintain that overruling Plessy was not justified until the country had experienced more than a half century of state-sanctioned segregation and generations of Black school children had suffered all of its effects," end quote. I think that's the key thing. He says, no, we recognize that this case was wrong the moment it was decided. It wasn't like new factual evidence came in, and that's how stare decisis works. It's not you need new facts to then overrule the case. And then immediately after that too, because you then get into this bad this kind of bad path where you say, well, Plessy was completely constitutional up until these new facts came about, and then it was unconstitutional. It's a little bit worrisome. But then he gives this case right afterward, in which I forget the names of the court cases right now, but there were Jehovah's Witness school children who refused to say the Pledge of Allegiance, I believe it was, in class. And in one case, they said that the school had the right to essentially make them say the Pledge of Allegiance. And then 4 years later, they said, no, the school doesn't have a right to make them say it. They have this freedom not to say the Pledge of Allegiance. And the court 4 years later said there was no change. There were no factual changes that came to light in between these two periods. We just recognized that the court was wrong 4 years ago. And
right. Yeah, I think one of the examples that he adduces as well is actually even shorter of a time frame. There's one that we don't have to go searching for it now, but it was, but I think even just the 4-year example is more than enough to show that it's not just a, in light of new evidence sort of thing, that it can be judged independently. Things can be wrong because simply they're wrongly argued. They're egregiously argued the day that they're handed down, to use Alito's language. So yeah, I think honestly, there's something subconscious in why we spent so long talking about that, because we just like saying the word stare decisis a lot. I have to say I enjoy it. So if you want to talk for like an hour or more about stare decisis, I'm down for it.
No, it certainly adds to it. It makes you sound smarter than you actually are. At least smarter than I actually am.
Yeah, I know. I'm all about that. That's all I have. Just saying words that make me sound smarter than I am.
No, I think that covers most of what we wanted to say about the Dobbs decision itself. And again, so we have a great ruling, overruling an unconstitutional ruling. I think it's important also to say here is that your view on the court's ruling on if it was a correct decision or if it was an incorrect decision is, or should be at least, independent of your view of the ethics of abortion itself, right? Because you can think that abortion is totally morally justified and morally right, but that shouldn't have any bearing on if this case is actually, if let's say Roe was constitutional or unconstitutional, or if this, I guess you wouldn't say the terms constitutional or unconstitutional, but if Roe was, the court in Roe correctly interpreted the Constitution, or if it didn't do that, that the two are in some sense, they appear to me to be mutually exclusive on that front, on the ethics of abortion, and this, on if this case was correct. That's why you see even a bunch of legal scholars at the time that Roe was decided that said Roe was egregiously wrong, even though they supported abortion as a matter of policy, or the right to an abortion as a matter of policy.
Yeah. Well, speaking of the policy notion, I mean, there are a couple of quotes in Alito's opinion that have also just been circulating in general. I mean, even before the official decision was handed down, of those notable scholars. I think Lawrence Tribe was one of them, and there's a couple others. Although it must be said that Lawrence Tribe claims now that he has been misquoted by Alito. Again, we don't have to wade into that whole thing, but there are a number of notable scholars and jurists, at the time of Roe and in the ensuing years, who recognized, kind of the illegitimacy of the reasoning on a legal standard, even though they're, full-throated defenders of abortion access. They recognize that it's a policy, it reads like a policy prescription, not a legal opinion. Speaking of Roe, of course, and then Casey following. So yeah, I do agree that there is a difference. You have to make the distinction between the actual decision itself and one's view of abortion. Of course, as it plays out, those lines are never quite so clear, but in the way people act and the way their opinions are formed. And I would certainly, had Roe, had the decision gone the other way, it certainly would be very difficult to swallow that pill. But thankfully that's not the case. So
yeah. And that it's difficult sometimes to try to say, oh, well, I want the court to rule the right way. And when you know that maybe the court ruling in the right way is not the outcome you would like for it to happen. And so it's hard to disentangle, okay, do I like this outcome because it favors what I want, or do I like this outcome because it's actually just the correct way? Or maybe I don't like it, but I can recognize that it's the correct way of understanding the law. I think now that we've kind of broken the weeds, we understand. So what Dobbs v. Jackson doesn't do, right, is Dobbs v. Jackson doesn't outlaw abortion in the country. It overrules the precedents which say that the states couldn't outlaw it before this certain time. So what that means is now the states, the people can now vote as they want for how their abortion laws are going to be set up in their state. And I think that's a very again, going back to what the court's saying that the states can or cannot do, the court is now saying that the states can restrict abortion for legitimate state interests, and that could be in fetal life or to protect the medical industry from basically looking like they're committing extremely awful acts, which in abortion they are. But the court actually gives a lot of leeway for the restrictions that states can do up until the point of fertilization, really. I don't know if you have anything.
Yeah, no, I mean, I think that's a good way to sum up, like it replaced the restrictions on restrictions that Roe and Casey set forth with just a rational review basis of laws produced by the legislature, which is basically just that if a law can be proven to have legitimate rational interests of a certain party, then it passes that sort of standard of review. So it's very difficult. As far as I understand, it's very difficult to strike down a law on rational review basis unless it's completely absurd. And by absurd, I mean actually absurd. Like it doesn't have any rational content or direction to it. It's not a matter of I don't like this or I really like this. It's a matter of like, is this forwarding a legitimate interest on behalf of a certain group or party, or it could just be a person or a group of persons. So
And so I think with that said too, we now see that okay, this is a big victory because now states can actually restrict abortion to protect the unborn. But this obviously, as we mentioned in the beginning, is just a first step, a big first step, but just a first step, because now the fight happens in the public sphere on how things occur. So obviously there are certain states that are restricting abortion, and some of them right at the moment of fertilization, which is fantastic. But then other states, like my home state of New Jersey, which is essentially allowing abortion, for the whole duration of the pregnancy and celebrating that. And so obviously now the fight continues, because now we see that there's this disparity in what states are protecting the unborn and what states the unborn are allowed to be murdered. And now that there's the question of how do we continue the fight, and there's also like this kind of prudential question. There's some people who think that as it stands now, and I would consider myself to kind of be in this camp. There's other also law professors like Robert George, who also kind of, and John Finnis, who kind of agree with this idea that the Constitution as it is now can and should be interpreted in such a way that the unborn are recognized as constitutional persons under the 5th and 14th Amendments, and that they should have constitutional protections under that. And others who think, and Kavanaugh writes about this in his concurring opinion, that he says that the Constitution is completely neutral on the question of if on abortion. He says that the Constitution is not pro-life or pro-choice, and so he says that this has to be fleshed out by the states. And so there's this prudential question: do we try to work our way from the top down and say, okay, we should have the courts interpret the Constitution in this way, which I think would be a legitimate interpretation of the Constitution. But again, there are prudential questions of how this goes about. As Catholics, we all agree that abortion is wrong and ought to be outlawed across the country. The question is, how do we go about that? Is it the court saying that, or do we have this kind of grassroots effort and change the people's hearts and minds? In the end, we want to make not only abortion illegal, but we also want to make it unthinkable, something that people don't even consider as an option, as a legitimate option for themselves or for their livelihoods. And so there's that question of what approach do we go about?
Yeah, it's interesting you mentioned how like the fight is still being fought in a very practical sense, that the fight has only just begun, really. Obviously, and I should be more careful when I say that. Obviously, there have been tremendous strides in just building up a pro-life movement over the last 50 years in the wake of Roe. So I don't mean to diminish that at all, but like the actual political battle can now be fought rather than it just being a movement. Again, I'm not disparaging. Of course, we probably wouldn't have this decision without the blood, sweat, tears, sacrifice of those who have dedicated to this cause. So again, I want to give my due respect to that. But what got me thinking about your comments about this kind of or top down, as it were. If it was if one interpreted the Constitution in such a way that it would ban abortion, which I agree with you. I think that the Constitution, along with the Constitution, can be interpreted in such a way, or the more grassroots way, where it's about maybe converting hearts and minds, and going the legislative route instead of the constitutional route. So anyway, it's all to say that you have a renewed fight, or a renewed political fight between those who are pro-abortion and pro-life, right? But you're now also going to see, and I think you already are seeing, the intra pro-life battles between, okay, how do we now? Okay, now that it's up to the political process, how do we go forward with this? So I think it's a good thing, because it's going to be hopefully a healthy and charitable discussion among people who believe that share the same goal, which is not only abortion being illegal, but, as you say, unthinkable. But it's definitely something to keep in mind, that the fight isn't over between pro-abortion and pro-lifers. The fight has only just begun, also between pro-lifers, about and I maybe using the word fight isn't the is a little bit more aggressive than it needs to be, but I think it will get into some very, very contested territory about the proper nature of state intervention, constitutional interpretation. You're already having this in Catholic circles, right? The big fight between the integralists and those who are a little bit more integralists. So I think it's just gonna renew and enlarge and intensify some of these debates. Of course, I find myself a part of these debates a lot of the time, so I'm excited, and not only excited because on an intellectual level it's great, but also like in terms of being pro-life. I mean, it's really about protecting the sanctity of life in our political communities, in our communities generally. So it's something practicable, something that the stakes are really, really high, and within the stakes are not only really high, they've always been high, but they're within our grasp now. It's just how I would put it.
Yeah, you mentioned this the other day. It's now they're in our grasp because, I mean, the court has let it be in our grasp, right? The court in Roe and Casey, they kind of there was debate ensuing even before Roe and Casey. Obviously, it's not like the debate about abortion started after Roe was ruled. There's always been debate about abortion, of course, but as the justices, as Justice Alito writes in the majority opinion, the court kind of ended that debate when it decided Roe. It ended it, and then the court took for itself the power to say, this is the kind of restrictions that you're gonna or these are the kinds of things that you cannot do. And so this is the first time in my lifetime, at least that I'm aware of, that I've seen a branch of government, as you mentioned the other day, actually give power to the people, actually give up its undue power, the power that it took for itself wrongfully. And so it's fantastic to see that. That's just huge. That rarely happens, that once the government gets power, it lets go of it.
Right.
And so we see that, but now with that, we do have this larger responsibility, because it's in the public sphere now. We can do things about it. And so we've been having these conversations about abortion before, and we've had these debates or arguments or discussions with friends, family, maybe enemies as well. But those arguments, in some ways, they could do a lot, because it's great. We want to also change the hearts and minds, but they can only go so far. But now we can change hearts and minds, and those changes in hearts and minds can also lead to changes in how people vote. And then those changes in how people vote can lead to changes in how legislators actually protect human life, and how they recognize the sanctity of human life. So it's just to say that now the debates and the discussions that we have with people have these immediate consequences that are much higher, or maybe much more immediate. That's probably the best way to put it. And so I think that because of that, now the onus is on us as people who want to protect life. Maybe you're watching this, if you're watching this, you're probably Catholic. Maybe you came across our channel and you're Catholic. And so you obviously recognize sanctity of life, but also there are non-Catholics out there who protect life. There are non-conservatives out there who think that we need to recognize sanctity of life. And I'm thinking off the top of my head, accounts like secular pro-life, that are a group of secular people who try to fight for pro-life advocacy, or Dems for life, Democrats who try to fight for life. I know it's crazy
Well, it wasn't that long ago when you had, many Democrats who were, who were pro-life. It wasn't super uncommon to have that.
Yeah.
Like Dan Lipinski is one that comes to mind, and of course he was like primaried a couple of elections ago. But yeah, but of course now it is the partisan sorting is in full effect.
Yeah. But all that to say, though, is that now no matter who's watching, religious, non-religious, conservative, liberal, if you believe in the sanctity of life, and you believe that life in all its stages needs to be protected by a law, and recognized as having value, then now is really the time to make sure you know how to have these discussions with people, with your friends, your family, especially them, because those are the people you're probably most likely to change your minds, and because I mean, someone you don't know, they're just gonna be, all right, this is some crazy wacko that's just going on about these clump of cells. But your friends and family, if you've cultivated a strong relationship with them, they know you, they respect you, they love you, and they might say, okay, you might have something worth listening to, even if I disagree. But now's the time to really know the arguments surrounding the debate, understand pro-choice arguments, pro-life arguments, not use bad pro-life arguments like the fetus is only potential life, which is a bad argument. We can go into that in another video. But I think that now we have just this higher duty to be able to better understand the discussion, because the stakes are so high. It's not like marginal tax rates where it's like, okay, I might get another $10 taken off my account. It's like, no, they're actually living people that are their lives are threatened in this. And I think we just need to kind of elevate that discussion, not only to be aware of the truth of the matter and think through it logically, but also how to say that compassionately and with a lot of charity to people who are really kind of stuck in this mindset that this is the only option, or they need true liberation from this horrific act of abortion.
Yeah, it's very well said. And I think it will have not only ramifications for abortion, but also just politics, legislative politics in general. I mean, one can only dream of a day when people drive during election season will drive by, and when they drive beyond the side of the road in their community, when they see the campaign signs for their state representative, they don't go, who? They go, oh yeah, that guy. It really, it is quite amazing that we're in a position like you were just mentioning a couple of minutes ago, that power has been returned to its rightful place, at least according to the design of of our political order, right? It's not to make a normative judgment. That's just to make I would like to think it's just an observation about the nature of the courts and the legislatures. So it's interesting how the return to the existing structures, prior to maybe, let's say, the progressive era, is like something that's so novel and so new and so surprising. But it's a happy surprise in this context, to be sure.
Certainly. Yeah. So honestly, I don't have any more to add. I don't know if you do. I would just say, make sure that now, if you're pro-life, make sure you read up. You got to be informed. Get ready for the discussions. I'll leave a link down in the description. We'll link the Supreme Court decision, and I'll also link some other pro-life resources that are just really good to look at now, because now it's I mean, it was important before, but as we mentioned, the effects are so much more direct. But I think that's what we'll leave it off for today. And until the next time, we'll see you guys. God bless.